Let's talk today about when an employee being overwhelmed can genuinely trigger a $40,000 ADA lawsuit. Now remember, everything we're going to talk about today is general information only. This is not legal advice. Everybody's situation is different, and it will often be in the little details that make a huge difference for your obligations as an employer and the risk of liability you may incur. So if you have any questions, comments, or concerns about your particular situation, make sure you seek the advice of qualified legal counsel. Everybody gets stressed at work. It's a normal reality of workplace culture. And for the most part, somebody being stressed doesn't really matter much for legal obligations and liability. But what if I told you that sometimes that stress may actually trigger some obligations on your part that will get you in trouble if you don't handle it properly? Sometimes employees will either have or start developing conditions, and all of a sudden that stress that they were experiencing might actually now affect that condition. What does that mean for you? It means that now the employee might actually have a disability under the Americans with Disabilities Act and similar state laws, where now you have an obligation to do something about it or potentially risk liability on the back end. Let's think about conditions like depression or anxiety or autoimmune disorders or any other type of condition where stress might be a particular trigger or sometimes even a cause for it. Even if the stress itself may not be protected under law and requiring you to engage in any sort of action, the underlying condition might. And if you are aware of that condition, you now have an obligation to engage in the interactive process with an employee. What's the interactive process? The interactive process is nothing but a dialogue that you have to engage with an employee when you know or have reason to believe that they have a disability under the law, and to discover whether or not that disability is affecting their ability to perform any sort of part of their work. If the employee's disability is in fact affecting their work in some way, shape, or form, you may have an obligation to accommodate it, or otherwise find some sort of solution in order to help the employee make sure that they can actually perform the essential functions of their job, notwithstanding the disability. Now here's where things get tricky. A lot of folks really dismiss stress as just like a normal, everyday thing that people experience, and that may often be true, but the whole point of the interactive process is to find a solution for the employee to make sure that they are able to perform the essential functions of their job, notwithstanding their disability. That is, it is incumbent upon you, the employer, to start a dialogue in most places with an employee to say, hey, we know that you have this issue going on, or we think you have this condition. Is it affecting your ability to do your job in some way, shape, or form? And if it is, let's see if we can accommodate you to make sure that this is not a barrier to your ability to do work. Now, how this plays in with stress is that with stress, or somebody just being overwhelmed, you might be quick to dismiss it. It's a normal part of everyday working culture. Sometimes people get stressed and they just need to kind of, manage it a little bit better. But if it's tied to an underlying disability or a condition, you might have an obligation to engage in the interactive process. And in most places in the country, your failure to engage in the interactive process can in and of itself be a trigger for liability. So what does this mean? This means that you dismissing stress as just an everyday occurrence or not that big a deal or not really something that you need to deal with, you quickly dismissing an employee being stressed or overwhelmed is just one step away from you incurring liability, because dismissing stress and an employee being overwhelmed can be just one step away from a discrimination liability in and of itself. If you have some knowledge or reason to know that an employee has an underlying condition affected by stress, your dismissal of that stress might cause you to not even think about the interactive process. And missing that process in and of itself can be the basis of a claim, and one you might actually lose, even if you didn't mean to do anything wrong. Now, that doesn't always mean that you need to change a job function, restructure a role, or affirmatively make any sort of accommodation. Sometimes you will, sometimes you won't. But just missing the process in and of itself can be a problem in most jurisdictions that's going to cause you to incur some liability. Now, nor should you jump to just take your PTO or make well-meaning comments to an employee such as, it's okay, everybody gets stressed sometimes, you just have to power through it and you'll be good on the other side of it. The right intentions really don't make that much of a difference in employment law. It's the impact. And the impact there is that you've swept the problem under the rug, whether you think you did or not, whether you even meant to do it or not. So don't be so quick to dismiss stress as just someone complaining, especially when you know or have reason to know that an employee has an underlying condition that may be impacted by stress, because that dismissal might be the reason that you get a judgment or a really angry demand letter on your desk. Now, if you're dealing with any of the situations that we've talked about here today and you need some help navigating it, click the link below to schedule a consultation. Thanks for watching.